Person of interest time, Grant Muller with us in studio. And before I let you guys continue with this chat, what does it take for one to become senior counsel?
I think the statutory requirement first is that you must practice for 15 years. Then first, it's a title given by the president. It's conferred on by the president.
Okay.
15 years experience, exemplary service to the profession and to the country. Yes.
So if getting 15 years is just the basic.
Yes.
And then after that, the president and everyone else would decide, whether you serve it as an exemplary or not.
I mean, there's a tradition that every chairman of the law society becomes a senior counsel.
Okay.
Because in most countries, I mean, that's what happens. In England, many years before, I think, they changed. Once you become a chairman of the Bar of England and Wales, I mean, you are knighted by the Queen. So I think in Kenya also, once you become chairman of the law society, like many countries, you become a senior counsel.
All right.
Then after that, we admit 2-3 years.
Okay.
2 to 3 or 4, maximum 4 senior counsel every year. And I sit in that board that admits.
All right. Karibu sana.
The next senior counsels.
Yes.
We are working on James, hopefully one day joining that elite group.
I will give him a fair hearing.
All right, karibu sana.
All right, person of interest time, a bit late, but yes, we have to get into it. But first, let's set the stage for Ahmednasir Abdullahi. We'll get to that shortly, but karibu sana.
Thank you very much.
Let's start off from, from the beginning, all right? And we'll start from the Supreme Court. And we remember you, and Kenyans remember you as you fervently and stubbornly, standing there and saying, you know what, there cannot be any other decision, that would say this election, was stolen or whatnot. The Supreme Court has to decide this way. You're fervent. And you are said at that time to be for this government.
No, let's get it right. I wasn't representing either the president or the vice president in that petition. I was representing the chairman of the IEBC. And I said what I said, and what I said was the law, and I have no apologies. And if I was to say it again, I would say it, because that was the fact, and that was the law. And I think the Supreme Court did a wonderful job, despite, some people grumbling on the sides here and there. It did an excellent job, both in analysis of the law and facts. In 7 days, it had the case determined. And it stands out as one of the best decisions by the court.
Yes. Some are disputing that up to now, and we've seen, reviews from everyone else, colleagues, here in the country, outside the country, and one of the issues that sticks out, talk about first the timing itself, the 7 days period to hear and determine this case completely. As someone who not only participated in that and before that, was involved, in the laws and in the makings of this, do you think, with the benefit of hindsight, we need to tweak a few things?
First, those who are disputing it are not disputing it on the basis of the law. They are disputing on the basis of their political persuasion. So they are biased from that perspective, and they're entitled to. But let them not say because they are biased politically, the court did a poor job legally. The court did a wonderful job. And if you look at the decision of the Ghanaian case, which was after our case, that Ghanaian case, had very, very, very good words to say about the Supreme Court's decision in this country. And even in many countries, it's a good decision. In matters of time, it has its own pros and cons. If you make it 1 year or 2 months or 3 months like Ghana or some other countries, it will drag on. I think our time frame is excellent. If you have a tight case, you can argue that case within that time. But if you want to speculate, you fish, you don't know what you are doing, you grow up in the darkness, like, ODM, court was doing, then they will always complain that they didn't have enough time. But I think the time frame is okay. The court, it doesn't have to give the judgment immediately. The court gives the decision, then it can postpone the reasons. Yes.
A speculative question here. If you were to represent court on that petition, what is the thing that you would have done?
No, I have said right from the start, I will have advised them not to go to court because they had no case.
But if they had insisted, if I'm your client and insist, I want to go to court, what is it that
normally I advise the client, if he refuses to take my advice, I don't represent him. Court had no case from, the evidence they had. They just misunderstood some things. They thought they had a good case, which was hypothetical. One is IABC and the other parties replied, I mean, it was a case built on sand, it disappeared.
Okay, let's get to today, and the matters today. Ahmednasir, I want to get first, let's start with the issue that, today has been on the dailies and people are following, and that's the Anglo Leasing issue. So we're going to pay, some monies to IBC. We're told we must pay for us to operate in the international markets, for us to get credit, for us to get whatever it is that the government must get. But talk to us about in terms of legality of these issues of Anglo Leasing first.
Anglo Leasing has a long history, and I was involved from many years back when I was chairman of the Law Society. I was the chairman who took the main players of Anglo Leasing to court. We charged them with 3 offenses under the penal code. When we took them to court, they were invited to take plea. On the day when they were supposed to take plea, Amos Wako, the Attorney General, entered a nolle prosequi, and that was the end of the case. But Anglo Leasing has a long history. We all knew, and even I wrote personally myself about this, because when these suits were filed, the people who were in power were people who were working with Anglo Leasing. So they told the Attorney General not to instruct lawyers, or if they instruct lawyers, not to give them any papers. So the first part of the case, the Kenyan case, the Kenyan government really didn't defend the case.
That's why the case collapsed.
That's why the case collapsed. But this Anglo Leasing, these contracts specifically relate to Kenya Post and Telecommunication, or the Postal Corporation of Kenya, and certain, communications. When the judgment was obtained, the British government gave the Kenyan government evidence of corruption. One of the parties that was involved, Anglo Leasing, was depositing money in his daughter's account in the UK. So the British government told him, this is the evidence we have. There is money that's coming to this girl's account. Why don't you go to court and, mount it? Reluctantly, they went to court, although not very well. Then Anglo Leasing brought one of its witnesses, who is Chepkonga, this MP for Nimoy. And they gave evidence that was very crucial for the case. And that's why the Kenyan government collapsed even on appeal. Yes.
Should we pay?
There's a judgment. What do? There's a judgment from a court of competent jurisdiction. What options do you have? You have to pay. If you want to make a political decision, you can default. You can refuse to pay. Then they can sell one of your buildings in either the UK or in Switzerland or in these countries. I think the point is not whether we should pay or not. We should pay, in my view, but we must recover this money from those people who are negligent in the Attorney General's office, right from inception up to today. If people are not made accountable, this will happen again and again. There are many Anglo Leasing, there are 18 contracts. If this one gets judgment, there's a good chance that everybody else may come to court.
Because it's a precedent.
There's a precedent.
Yes.
So those people who, the Attorney General's office, really, the buck stops there. Why didn't it not instruct lawyers? What was the kind of instruction that was given? Why did we lose the case? Because this is a case was so easy to win. If they will have entered a defense, the chance of losing will have been less than 2-3%, because it's a case based on corruption and phantom contracts. Yes.
But we have a different AG now. We all had, high hopes and dreams about this new AG, your friend, Githum Guy. So, your article the other day. Do you feel that at this particular point, we're not getting that sound legal advice for the government and someone who's there to stand for the country and stand for the people, as opposed to, the paymaster?
Yes, when the president wants to appoint his Attorney General, he decides what kind of person he wants. And there are so many lawyers, he can appoint from, very qualified. But, the criteria for appointing Attorney Generals in this country is that, who will give me advice as I want, who can predict the advice I will require.
Yes.
So those are the kind of guys they want. And history will judge them at the end of the day. Amos Wako didn't do very well. Guido is doing very badly, in my view, doing worse than Amos Wako, in my view. So, it's not for me really to judge. That's for the president to decide what kind of advice he requires. But I agree with you that the Attorney General's duty number one is to look after the interest of the public. And this Attorney General, like many others, are not looking after the public interest. Yes.
Let's talk about the other issue that also has been big and been profound, and it's been there for a while. Talking about terrorism and this discussion about granting bail for persons who have been arrested or being suspected of being terrorists. Let's start from there as we go deeper to the other, anti-terrorism issues and the police swoops and all that.
I mean, bail is a constitutional right. I mean, even murder, murder cases under the Constitution now is a bailable offense. There is no offense that's not bailable now. So when someone commits, either a terrorist act or not, he is entitled to bail. But it depends on the magistrate, who's listening to the case to satisfy himself whether, he's flight risk, whether he deserves this, whether, there are certain parameters that the magistrate will look into. But, everybody is entitled to bail, and it is the magistrate that will decide. What I found what is wrong is, for example, the vice president or someone in the executive to give directions to the judiciary and say that, we don't, those era gone, you can't direct the judiciary to do what it wants to do. There's a law that will determine how a magistrate will handle. But the mindset that, someone like the deputy president can talk and say that, the judiciary is not fighting. The judiciary fights terrorism or any other offense according to the law. You should not expect that the Chief Justice to come to the press conference and say that, we are siding with the government, we will not give bail, or,
But the other jurisdiction, specifically the UK and the US, when handling matters of terrorism, they thought fit, and they said it's fit that in this kind of scenario, first, even the Supreme Court would agree and say, in some conditions, some situations, you don't grant bail, all right? And they changed their anti-terrorism laws or something to give power or teeth, if you like, to the law enforcement. Is that a way that we should go? Should we legislate on that?
England and America are very different. England, the law is still very strong. The judges are, they don't jump to the political bandwagon like they do in America. Liberties are more treasured, in England than
the US.
And even all this, if you look at England has changed the law. There's one decision of the High Court, then they change the law. Then the court says even that law is wrong. So they've almost given up because ultimately it's the court really that decides who gets bail and bond.
Yes.
And all these issues of terrorism. America is a little bit more draconian because of, the politics of a superpower and the role they play in, this global COP aspect. But there is really, there is enough law to address the issues here. What we are lacking here is the resources. What we lack here is the proper manpower. If you look at, for example, our intelligence, the NSIS, it almost spends 80% of its budget on listening the telephones of, Kenyans, politicians. It's involved in the politics of ODM and PNU. It spends a lot of its money on the referendum, the constitutional referendum. Everybody knows, for example, that they funded the No campaign. Our intelligence spends money on petty politics. And that's because they are not accountable to anybody.
How do we make them accountable?
You have to pass legislations to say that, they're accountable. This year the budget is 18 billion unaccountable. How do you spend 18 billion of taxpayers' money without accountability? Yeah. Not to Parliament, because Parliament, they will pay them small money here and there, then they will do what they want. But there is need for the intelligence or all the security organs to be accountable in terms of how they spend money. And that's why 18 contracts of the Anglo Leasing are all security related. That's why corruption in this country occurs. The security organs is the den of corruption, and that's why we have spent so much money. We allocate so much money for the police, the intelligence, and the AP, and they don't spend it because someone in the OP steals that money.
The swoops that, a few weeks ago, starting initially, spreading its way to South Sea, and the newspaper's headline today talk about, xenophobic, Kenyans are getting xenophobic, against members of, Kenyan Somali look, like Somalia something. First, were we justified, to go into Somalia and cordon off Somalia and spend a lot of time there,